and defend the Constitution of the state of Illinois.
Is that the oath we took? Or was the language prescribed in the statute that we support the Constitution of the United States and the Constitution of the state of Illinois? And isn't that the same oath that every lawyer, every person who comes to be admitted into the bar of Illinois under the Attorneys Act takes the same oath?
In this instance,
So are you saying that every lawyer in the state of Illinois has standing to challenge a statute they don't like?
I'm not arguing that, Your Honor. I'm saying that state's attorneys and sheriffs stand in a very unique position. For instance, state's attorneys are the only ones that can go into a courtroom and file a petition under the Defendants Act to deny bail to someone.
Isn't that true now?
That is true, Your Honor, except in this instance, we would be asked to enforce a rule that plaintiffs believe is unconstitutional. I think under Lujan, this court found that if we are regulated by the act, we are a proper party to that litigation. And plaintiff state's attorneys and sheriffs are certainly regulated under that act.
And you are adversely, what is the language of the case? Adversely, there's an adverse impact on your rights. Is that right?
There absolutely is, as the circuit court found. State's attorneys, prosecutors have an inherent interest in ensuring that we can move cases through the court system, that we can secure a defendant's appearance at trial. The sheriff has an inherent interest.
Why don't you continue to have that right?
I'm sorry?
Why don't you continue to have that right? If you say it's a right, a constitutional right, I'm not sure, but you say you have a right to ensure the defendants appear, to continue to appear. Doesn't that continue under this act?
Well, the act abolishes the opportunity for a state's attorney to even request a monetary bail as a sufficient surety. And for the sheriff has to ensure effectively the safety of every law enforcement officer under his charge. This act requires them to serve, for instance, notice to appear and then a warrant on 2 occasions. We've now doubled the number of instances where law enforcement is going to come into contact with perhaps a fugitive or a very dangerous individual. So plaintiffs squarely believe that prosecutors and sheriffs have standing to pursue these matters. And we further believe that the act is unconstitutional. It's quite simple.
Counsel, can I ask a question?
Yes.
Is your argument any different as it relates to the victim's rights clause as far as the standing argument?
It absolutely is, Your Honor. Even the defendants have conceded, I believe, page 835 of our appendix in our brief. The Attorney General says in one of the pamphlets that the state's attorneys are able to not only assert the rights of victims, but in many instances, we are required to, and we may be the only party that can assert that victim's rights. So I believe we absolutely have standing to pursue this, not only on behalf of prosecutors and sheriffs, but also on behalf of victims.
Doesn't the constitutional amendment, or I think maybe it's the statute, involving victims, crime victims' rights, say that the state's attorney can assert those rights in the case? As in the case, the criminal case pending in the court.
It does say that, Judge. We're, of course, here on a deck action. The alternative to this forum and pursuing it in this case would be that we would have to stand by. We would literally have to sit on our hands and wait for a victim's constitutional rights to be violated or a defendant's constitutional rights to be violated. I go to work every single day to prevent that very injury. So again, plaintiffs believe that we do have standing, we are proper parties, and the simple way for the legislature to accomplish all of these reforms, take the question, put it on a ballot, propose it to the people, let them vote on it at an election. It quite simply is that easy. And this court, in the Supreme Court Commission report, identified 2 such examples of where that actually occurred, New Jersey and New Mexico. In both of those states, they accomplished comprehensive and significant bail reform, but they did it through the amendment process. They let the residents of their state have a say. They made sure that they followed the will of the people. And Illinois has done that too. Defendants talk about 6 decades. Let's focus on the 80s. In 1982 and in 1986, the Illinois legislature, when they wanted to expand the list of non-bailable offenses, what did they do? They submitted that to a vote of the people. Very significant, because in this instance, this time, they've not only tried to expand the list of non-bailable offenses, but they have all but abolished the condition of monetary bail as a surety, and they tried to do so through mere legislation. They literally tried to drive the reform by following 764 pages of directions at 4 a.m. in the middle of the night, in the dark, with an hour to get there. And unfortunately, they took a few unconstitutional turns along the way. The Illinois Constitution is clear. All persons shall be bailable upon sufficient sureties, with few exceptions: capital offenses, crimes that are punishable by life, by a sentence of life, and non-probationable felonies. With this act—
Mr. Rowe, let me ask you the same question I asked your opponent. Is public policy a factor in the legislature setting parameters for pretrial detention?
In many instances, Your Honor, yes. In this instance, however, as the court has said in best, the issue before this court is not whether this is a good idea or something wise to do.
That's not what I'm asking you, sir. I'm asking you whether public policy is a factor in the legislature setting parameters for pretrial detention.
It is, so long as that does not result in legislation which conflicts with the Constitution. And they are free to set public policy, but on some occasions, such as in this instance, they have to take that to the vote of the people. Now, even the defendants here have conceded that Article 1, Section 9 in its current state, pre-Defendants Act, grants a judge the authority to set a monetary condition of bond. The act, by its plain language, by its very title, abolition of monetary bail, has abolished the court's right, a judge's right, to set a monetary condition of bail. And in doing so, again, they are attempting to forego the will of the voters, and they are attempting to drive this reform through mere legislation. Article 1, Section 9 also unambiguously lists the offenses that are non-bailable.
Mr. Rowe, let me ask you another question. Is setting monetary, what's the purpose of setting monetary bail as you see it?
Sure, there's actually, it serves two purposes. One is, of course, the defendant's interest in liberty, but that is balanced with society's interest in securing and ensuring that the defendant does appear for trial and to participate in the court process.
Okay, so is money the only way to achieve those ends, in your opinion?
I don't believe that the plaintiffs are arguing money is the only way, but certainly in some instances where a judge would find that non-monetary conditions are insufficient, the judge should have that tool that the people of Illinois have put in that judge's toolbox, and that's the ability to impose a monetary condition of bail. So as we look at this legislation, in addition to abolishing monetary bail, it has also added certain offenses to the list of non-bailable offenses. Again, in the 1980s, they went through that amendment process. They did it the right way. And then suddenly in 2021, it would appear that the legislature simply just didn't trust the voters. They tried to do it through mere legislation, which this court has said they cannot do. In Hemingway.
Mr. Rowe,
Yes.
be so kind. Your time is up.
Apologize.
Good morning, Your Honors, Madam Chief Justice, Honorable Justices of the Supreme Court, Counsel, may it please the court. I am Special Assistant State's Attorney Alan Spellberg, here on behalf of Will County State's Attorney James Glasgow. I'll be addressing the separation of powers argument. The Circuit Court here properly found that the pretrial release provisions of the two acts at issue unduly interfered with the judiciary's inherent authority to set bail. And what counsel said is that this court has never held that judges have the authority to set bail, that Hemingway is a more narrow decision and only gives the authority to deny release in certain circumstances, is not correct. Because this court in Bailey expressly held that trial courts do have the power to set bail, the inherent authority. In Bailey, the legislature adopted a new provision holding certain defendants charged with aggravated stalking without bail. The defendant in that case argued that the statute allowing the no bail hold unduly infringed with the judiciary's inherent authority to set bail. And this court held it did not because it was just an appropriate determination, but because the statute retained the judge's discretion in all instances. the judge always had the power to impose bail if he sought, or pursuant to statute could hold the defendant without bail. That is what is lacking in these provisions which are issued, because under the provisions that have been adopted in the Safety Act and the follow-up mandatory provisions, every judge in the state of Illinois is prohibited from considering a monetary component of pretrial release. And in fact, in some instances, the judges are prohibited from holding a defendant or from imposing bail, even if they believe that there are no set of conditions which are available to safely ensure the defendant's return for trial. That is why the trial court found that the statutes violate the separation of powers, and that is why this court should affirm. Because when a legislature adopts a statute which unduly infringes, which prevents the court from exercising its historic and well-settled discretion over matters that go directly to...
Mr. Spellberg,
Yes,
how
Your Honor.
is this any different, however, than, automatic add-ons for weapons, or, 15-year enhancements, or minimum mandatories, or, automatic sentences that have been imposed by the General Assembly for which we have no discretion?
Your Honor, there is a significant difference, and as this court recognized in Taylor, which we cite in our brief, the sentencing authority is a concurrent authority between judges and the legislature. The legislature has the undoubted authority to set and fix punishments for offenses. That's what this court said in Taylor. And then the trial courts have the concurrent authority to impose the particular sentence in the case. So when there is that concurrent authority, that explicit concurrent authority that exists among the different branches, there can be no separation of powers violation because the branches are expected to work together. What's different here, however, is this court recognized in Hemingway, in Gendron, in Bailey, is that the judiciary has an inherent judicial authority to set bail, to deny bail, to control the proceedings before it, because it is necessary to maintain the administrative functions of the court, to maintain an orderly process of criminal procedure. So that is why sections 110 in the Code of Criminal Procedure, which in Hemingway this court went through, in Gendron this court looked at as well, that is why those provisions are constitutional to the extent that they have always allowed the judges the discretion to make the ultimate determination.
May I ask you this?
Yes, Your Honor.
Mr. Spellberg? In your brief at page 40, you say, determining the appropriate surety to compel the appearance of a defendant is a judicial, not legislative function. And then you say, the acts unconstitutionally interfere with the court's inherent authority to determine what constitutes a sufficient surety to secure pretrial release. Now, as your opponent has mentioned, but I'd like to direct your attention to 725 ILCS 5/1103, legislature for many, many, many years has, the statute's been on the book for a lot of years. That statute is entitled Determining the Amount of Bail and Conditions of Release. That's the act that then indicates that, and it says this specifically, in determining the amount of monetary bail or conditions of release, the court shall take into account, and then goes on to set out 36 specific factors that the court must take into account. Is it that statute unconstitutional because it interferes with the court's inherent authority to determine sufficient surety?
No, Your Honor, it's not, because while the legislature has listed a series of factors to be considered,
Shall be considered.
It shall be considered, yes, Your Honor.
The court must shall take into consideration these factors. Isn't that the legislature working with, or maybe interfering with, the court's?
Your Honor, respectfully, I disagree. And the reason why is because
I know where
even though
she's
the
going with
legislature
this.
has mandated that certain factors should be considered,
I know where she's going
absolutely,
with
it has not mandated the outcome. It has not mandated the determination that should be made after the consideration of those factors. And I would direct this court's attention to the case that we cite in our brief, a case that was relied upon by the circuit court in this case, but is nowhere cited anywhere in the defendant's brief, which is the Best versus Taylor Machine Works. That case is the critical seminal case for addressing when the legislature has unduly interfered with an inherent judicial authority. Because in Best, what this court found was that when the legislature mandates a particular remitter in a tort action when it holds that as a matter of law, certain amount of damages exceed the public policy as appropriate, that the courts must reduce it. This court said that that violates the inherent judicial authority to control the cases, to manage the litigation, to determine whether or not as a matter of law, a particular award is excessive, because it takes away that inherent judicial authority. It is controlling the outcome, which is why it's improper. In the example that you give, Your Honor, with the listing of all of the factors that have to be considered, nowhere in those statutes did the legislature mandate a particular outcome. Excuse me. But in the current statutes, which are at issue before this court, the legislature has mandated a particular outcome in any number of situations. Most importantly, the legislature has prohibited judges from considering a monetary component in every single case. And as we know from history, monetary components are an important incentive for ensuring the defendant appears at trial. Gendron especially holds that the purpose of a sufficient surety is to ensure that the defendant will appear at trial, and that by doing so, having an economic loss, the risk of economic loss by the defendant, by his family or his friends, is what satisfies a sufficient surety. Then Bailey as well, the right to bail. All of those cases, there is hundreds of years of history in both Illinois and around the country of monetary components. Not that they're mandated, but that they're allowed to be considered by the judges. And so in that instance, that's one way that it affects the trial court's authority in every single scenario at every single point. But even more so under section 110-6.1, the 90-day provision. If the judge has already ordered the detention of the defendant, has already found that the prosecution has established by clear and convincing evidence that the proof is evident and the presumption is great, and that no set of conditions is available to safely ensure the defendant's return to court or protecting the public, despite all that, once 90 days have passed, if the trial has not yet commenced, the court must release the defendant. No longer has any discretion to retain the defendant, to continue control what's going on. That cannot stand in the face of Hemingway, which specifically recognized that even where the
Don't know what happened. Hold on.
the legislature didn't
here we
have
go.
the authority to expand the category of non-bailable offenses, even where the statute that was the basis of the case was invalid, as the court said. The trial court still retained the inherent judicial authority to ensure that the defendant was present and to ensure that, if appropriate, to hold him without bail. And so that's,
Counsel,
yes, Your Honor.
You're making a facial challenge, right?
Yes, Your Honor.
And
we
so
are.
that means that you have to demonstrate that there is no set of circumstances that this would be constitutional. Have you done that?
Well, yes, Your Honor, as the circuit court found, because every single bond decision, the judges are prohibited from even considering a monetary component. That affects every single case. But, Your Honor, I would say, as we pointed out in our brief and as the circuit court found, in not a single case where this court engaged in a separation of powers analysis itself, where it looked to whether or not the legislature, excuse me, I'm sorry, I'm out of time. Thank you. If not in a single case has this court ever applied that type of analysis, that type of demand, that it be instead invest in LeBron in all the cases we list. What this court has simply done for separation of powers analysis is look and see whether or not the judicial authority has been impinged in some significant manner, whether it's been unduly infringed. And as I'm out of time, I would just simply ask this court to affirm and to allow the parties to go back and begin the reform of the bail process through an appropriate process. Thank you.
Thank you very much, counsel.
Thank you.
In rebuttal?
Thank you, Your Honors. I'd like to make a couple of quick points. So plaintiffs talk a lot about the importance of amending the Constitution and the fact that the General Assembly here should have put this to the voters. But the General Assembly was required to put this to the voters and amend the Constitution only if the Constitution currently requires the state to maintain the institution of monetary bail. And for all the reasons we've discussed, it doesn't. As to the separation of powers point, I think Chief Justice Tice's question is exactly right. Plaintiff's argument, if accepted, would bring down not only the pretrial release provisions enacted by the Safety Act, but also the entire scaffolding of legislative regulation of pretrial release in Illinois that existed for 60 years before the Safety Act's enactment. Plaintiffs have no effective response to that. Mr. Spellberg talked about Bailey, which he says, talks about the court's inherent authority to require monetary bail. Bailey is not about monetary bail. Bailey is a direct follow-on to Hemingway. It's about detention. The legislature and the statute at issue in Bailey said that courts can detain someone who's been charged with stalking or aggravated stalking. A defendant challenged that statute as inconsistent with the bail clause, and what this court said is no, the statute in question just codifies courts' power to detain the person. Bailey is a perfect example of the limited way in which of Hemingway's limited holding. In fact, the statute at issue in Bailey tracks verbatim one of the 3 exceptions set out in Hemingway for when detention is appropriate. It does not hold that courts have any inherent authority to set monetary bail. Plaintiffs talk a little bit about other separation of powers cases, kind of outside the criminal procedure kind of context. I heard a discussion about the Best case. We talk about this a little bit in the briefs. There are a lot of separation of powers cases out there. And what the court does in each of those cases is kind of looks to the historical tradition supporting the asserted judicial power and the historical tradition on the other side of legislative regulation. In Best, the issue is that there was no history of legislative regulation of what the court termed a legislative remitter. It was a kind of new thing that was being brought in to restrain courts' power. Here we have the opposite. We have 60 years at the minimum of legislative regulation of bail. Plaintiffs describe Best as, as sort of involving a statute that mandated a particular outcome, which they say is just like the detention provisions. But sentencing provisions, as Justice O'Brien mentioned, operate the exact same way. Sentencing mandatory minimum provisions mandate a particular outcome in a particular case. And they can't be explained simply by saying that the legislature in the sentencing context has some sort of concurrent constitutional authority to make public policy determinations, because this court has used that exact same language in Walker to describe legislative authority over the Code of Criminal Procedure and the Code of Civil Procedure. Those are contexts that are directly analogous to the sentencing context, in that in each case, the legislature is charged with making big decisions about the way that things should operate in the state. And that is the kind of fundamental point here. The legislature has made exactly that decision about the way that people should be treated while they are pending trial and presumed innocent. There is nothing in the Constitution that prohibits that decision. Plaintiffs talk about the 90-day provision. This is section 6.1. No, this is sections. I'm losing my notes. The 90-day provision, regardless of where it's enumerated in the statute, is, as we describe, a long-standing feature of Illinois law. It was enacted in 1988. It had essentially the same language then as it does now. It requires a court to release someone who is held pretrial after 90 days. What the Safety Act does is it gives the state and courts more power, not less. The Safety Act says that courts can can toll that 90-day requirement if the state seeks a continuance that is supported by good cause. That is a provision that was not in pre-Safety Act law, and it certainly accounts for the issues raised in plaintiff's brief about the delays associated with DNA testing, which I take to be their primary complaint in this area. So again, if plaintiffs are right that provisions like that violate separation of powers principles, suddenly we're not just talking about the Safety Act, we're talking about 66 decades of legislative regulation of pretrial practices that are all called into question by plaintiffs' expansive reading of judicial power and their narrow reading of legislative power in this area. Finally, I want to talk briefly about the sort of facial versus as applied issue that Justice Holder-White raised, I think that's right, Your Honor. I mean, at the very least, plaintiffs have not come anywhere close to meeting their burden of showing that no set of circumstances exists under which the detention provisions are valid. The detention provisions are consistent with Hemingway. They are consistent with the inherent judicial power to detain a criminal defendant pending trial in almost every case in which that power would be used. They permit detention on either flight risk or public safety grounds of anyone charged with virtually any serious felony in the state. That means they are consistent with the inherent judicial power described in Hemingway and most of the actual cases in which the state will seek to detain someone pending trial. It would grant plaintiffs an extraordinary windfall to find the statute facially unconstitutional and strike it down as to all parties in its entirety just because there might be some hypothetical case in which a court would want to detain a low-level misdemeanant and lack statutory authority to do so. So if the court, for whatever reason, finds that there is some, reason to hesitate and say that the statute is not sort of facially constitutional in all its applications, it should at the very least say that plaintiffs simply have not met their burden of satisfying the sort of demanding standard of showing that no set of circumstances exists under which the statute is valid. Plaintiffs point to a handful of separation of powers cases in which the court could have kind of more fully articulated its reasoning or perhaps even applied the ordinary standard for facial claims, but they admit that none of those cases establishes the exception that they are seeking, and in most of these cases, the issue simply wasn't raised. And so there's no reason to read these cases' silence as kind of a precedent that establishes a separation of powers exception to the ordinary rule. If the court has further questions, I would be delighted to address them. If not, we would ask that the court reverse the circuit court's decision finding the pretrial release provisions unconstitutional and allow the Safety Act to take effect. Thank you.
Thank you very much. This case, number 129248, Roe versus Raul, taken under advisement as agenda number 1. Mr. Marshall, the Illinois Supreme Court will be in recess for 10 minutes.
Wow. All 7 members are on the court. Wow. Wow. All 7 members are on the court. Wow. Wow. Wow.
Chip Brewster here, WGN News Now. You've heard the court has gone into a 10-minute recess. I'm unsure.
Wow. So the significance of that with Jacob, you already know the significance of that is, so what happened was J.B. Pritzker, sorry, my nose is still doing this thing. So J.B. Pritzker paid $1 million to 2 Illinois State Supreme Court justices for their election campaign. In Illinois, state Supreme Court justices are elected to 10-year terms. And I thought that 2 of those justices were going to recuse themselves. If this doesn't trigger conflict of interest judicially, ethically, I don't know what does. And so this has everything to do with those of you all who are following Second Amendment issues in Illinois. This also has everything to do with the likelihood of those same 2 justices appearing taking the seat or taking the bench in the matter of the case that is soon to come on the docket of the state Supreme Court regarding the FOIA card and the gun ban. That's what I meant, the gun ban. Ooh. Illinois, Illinois, Illinois. Illinois, Illinois, Illinois. And there's more things they're going to be discussing too. I don't know if WGN is going to still live stream it. This is really something. This is really something. You said you've been watching Todd. Yeah, Todd Vandermine is good. You all go over to Freedom Still YouTube page and follow him. He's amazing. But I know all 7 members of the court. Yeah. You say I might be live for the next 24 hours? Wow. Yeah, I'm thinking it's time to get out of oh my God, bro. Oh. Wow. Let me see where WGN is now.
What will happen after that 10-minute recess? Live courtroom right now. So one thing that I will say, let me go ahead and take off the behind the scenes part of this while I poke around a little bit. If you are unfamiliar with this case, now obviously there's quite a bit out there about it, and it's been talked about for some time, the Safety Act itself. But we have a nice synopsis up on WGNTV.com. If you have
Yeah, so he's just talking about the case. I don't want to listen to it too much. Wow. So for those of you all watching this on YouTube who are not familiar, Illinois signed the Safety Act, which talked about no cash bail. In other words, unless there's a specific set of conditions that are met, people are going to automatically be given the ability to be able to be released on their own recognizance, unless the state can prove that proof evident, presumption, great, few other things. Go back and look at my previous videos on the issue, okay? But this one is specifically talking about no cash bail. And the special assistant state's attorney for Will County argued for James Glasgow. The state's attorney of Kane County, I believe, or Kankakee County, he argued. And then the deputy solicitor general on behalf of the Illinois attorney general argued. You know what I would have loved to have seen? I would have loved to have seen Kwame Raoul actually get up and make an argument himself. He won't. He won't make an argument himself. I doubt it. I know Lisa Madigan, the former attorney general, she would have got up there and probably argued. She's got that experience. Kwame, I don't know. Yeah, this is something to watch. Okay. I'm still waiting to see what's going to happen. Yeah, you said Kwame likes to stay behind the scenes. Yeah. In fact, if you've ever listened to him during the COVID conferences, yeah, he's not really. Yes. Can you even bring forward proof? Yeah, there's a possibility in one of those that you would be able to bring forward proof in certain cases and ask certain questions of victims. Now, part of that I agree with, part of that I don't. Depends on the circumstance. But yeah, so that's wow. It is noted that those 2 judges, yeah, I don't know which judges it was. I don't know. But all 7 of them are there. So you could say that 2 of the 7, yeah. Yeah, you say you've been at the time of bail? Yeah. There is a provision in there that talks about proof. Love the content and real talk. Very much appreciate it. Knowledge is key for everything and every way. I appreciate that, Carrie. I don't know where this fucking bad cough came from. Let me not use the F word again. I don't know where this cough came from. It came out of nowhere. It's crazy. Other than that, I hope you all are having a great day. I don't know what they're going to do with this 10-minute recess. I know there's other stuff they're going to talk about on the court. That's what I'm kind of waiting on.
on our Facebook page.
Yeah, so the court is going to reconvene The attorneys will do, they're waiting to see if the case will continue, if the attorneys will do interviews. All right, so those arguments are over. There are other matters that's going to come before the court. And I caught the tail end, the mid to tail end of the argument. So I hope y'all are having a good day. You said it sounds like sinus drainage. Yeah, it's definitely that. Yeah, it's definitely that. I do have allergies. I have to go get stuff cleared and stuff like that. I've had allergies for quite some time. And I take care of that. So that's going to happen. It's definitely going to happen. You say you're a very big fan. I appreciate that. All right. So I'm not going to take up too much more of your day. Yeah, we'll come back and discuss it, but I did want to stream it so that you all can see what's going on. All right. Hope you all are having a great day. Hope you all are going to have a great day. And we'll talk soon.
What's going on, you? This is Instructor Mike. You can follow me on Facebook at Mike Brown or Instructor Mike. Follow me on.
It could be you as a citizen, and you walked up and you see somebody. It look heavy? I don't know. Create special. That must be. But it's good to know that this can handle the high pressure rounds of the flooding. Ready to go.
Make eye contact with me. He's still trying to get it open a couple of times.
So